Thanks for joining us for this succession certificate program. Succession certificate is issued to the successor of the deceased person who has not prepared a will, or in other terms, we can say that the individual has died intestate without leaving a will or a nomination for his assets. Assets, when we tell assets, it can be immovable or movable assets. Both are counted as assets. Movable assets, as all of you all know, it can be like movable, like bank deposits, fixed deposits, bank accounts, shares, demats. Whereas immovable assets are land, building, flat, etc. So now when we go to succession certificate, every person, layman has got a simple question. What is the difference between succession certificate and letter of administration? Because the courts use two terms for the certificate. One is the succession certificate and the other is the letter of administration. For movable assets, that is bank deposits, mutual funds, demat accounts, shares, that certificate which is granted by the High Court is called as succession certificate, whereas certificate or grant issued by the High Court for immovable assets like flat, land, building, etc., that is called as letter of administration. Only term wise it is different. One is called succession certificate, one is called letter of administration, but both are the same certificate with a different term used. So now if we have to go for succession certificate, before telling that, I would like to inform and, as a precaution, inform all the participants and their family or their relatives or their clients to please fill up the nomination form. If you can see now, during March, when the financial year is ending, there are numerous messages, WhatsApp messages, email messages coming telling that, informing the client, please fill up the nomination form. Just don't ignore the messages. Don't just avoid the messages, but go to the particular branch or go to the particular bank or go to the share company and have the nomination filed, because this is very important. For movable assets in the bank, nomination is very important, because if there is a nomination, you need not go for a succession certificate as per the prevailing law as of now. As of now, if you have a nomination, then you need not go for succession certificate. You can just approach the bank after the person dies, and you can fill up some of the forms which have been given by the bank and then clear your funds in the bank. But if your nomination is not filed, then the share company or the bank will ask for a succession certificate. So please, a personal request, I am also doing it now. So that's why I'm telling you all, please have the nomination forms filled up. Go to the particular branch, take a holiday for a day and go to the branch and have the nomination form filled up. This is for the movable assets. Now for the immovable assets, nomination you may fill up, but alternatively or subsequently have a will made for the person. Every person, because I am also an expert in making wills for senior citizens. So everybody who makes a will has got a thinking that, will banayenge to shayad kal mar jayenge. It is not that, we need to make the will so that whatever we have earned during our lifetime, whatever assets which we have created during our lifetime, putting our blood and flesh into our work, those assets are properly owned by our children. So that's why it is very, very important to have a nomination, to make a will, etc. and etc. Whatever the society says, whatever the bank says, you all please follow that and have your nominations filed in. Now, when we go for succession certificate, a succession certificate is a procedure followed by the court where when there is no will, there is no nomination made, and the person dies intestate. In this case, the court stands as an executor of the wealth what the deceased person has to have it given to the proper owners. Now, when we tell succession certificate, definitely everybody is thinking who are the successors. The successors who can apply for the succession certificate are the direct legal heirs under the Succession Act. That is the wife of the deceased or the husband of the deceased, the mother of the deceased, the children of the deceased, that is the sons and the daughters. The daughter-in-law also has got a right under the Succession Act. Now, when we come for succession certificate, there is a jurisdiction which is in Mumbai. At least I can explain about the jurisdiction from Kolaba up till Borivali. The succession certificate jurisdiction is Mumbai High Court, and beyond Borivali, it goes to the subsequent courts like the Vasai Court or Palghar or Danu, and here up till Thana onwards, it will go to the subsequent courts beyond that. Now, in succession certificate, the main thing is jurisdiction, and there is no timeline. You can, apply for a succession certificate at any given time if there is no will nomination clear in the assets. Now, jurisdiction-wise, in the Bombay High Court, it is the original side department. It is the original side in the Mumbai High Court wherein we apply for the succession certificate. A proper petition needs to be done as per the prescribed format given by the Mumbai High Court, along with the schedule of the assets, that is movable or immovable assets. We need to make the schedule of the property, a proper schedule. So what we tell our clients is to get a letter from the entity or from the institute or from the society or from the bank which is asking for a succession certificate. Because sometimes what happens is, at one time, I think so 4 years back, the amount was X, and today the amount may be X plus 2 or X plus 3. So what we usually ask our client is to get a letter of requirement of a succession certificate or a letter of administration from the particular company or the society which is asking for the succession certificate, so that we have got a proper figure with us. Now, in sometimes what happens is there are shares which changes every now and then. Maybe every day there is a change in the amount of the shares. So what we tell the client is, go to the website and the NSE website and see for that particular day, so that we can, write the amount as on date. So the petition on which date we have submitted, that date we put the schedule of the property, so that if there is any rise, that is increase or decrease, then it is irrelevant. We take on that particular day the schedule of the property. Now, in this, there is a court fees for the succession certificate or a letter of administration. That is for a letter of administration and succession certificate, if the amount exceeds 10 lakhs, which is a very nominal account. So it will be around rupees 75,000. And below 10 lakhs, then there is a percentage wise working for the amount calculator. So this is, if it is above 10 lakhs, it is 75,000. If it is less, then it will be percentage wise. Once the petition is finalized by the department, then we make a final draft of the petition, and when we submit, once the department accepts it, first we need to remove the objections if there are any by the department. Once the objections is removed, when we file the petition in the original side of the High Court, then we need to pay a court fees of the allocated amount. That is, if it is 75,000 or lesser than that, we need to pay that on the day of submission of the petition. Then the procedure starts of the succession certificate or letter of administration. That is, once the petition is filed, the objections removed, court fees paid, then the court starts its procedure. Like, where in between we need to get the surety, we need to file the affidavits, then the bond, then maybe after the procedure has started, they will ask for the NOC, that is no objection certificate from other legal heirs. Now there are 4 legal heirs for a property, and one person has come forth for the or for the transfer of the assets or the in his name, then there should be a no objection certificate from the other legal heirs. Now you all might think, if everything goes to him, what about the other legal heirs? There should be a consensual decision between them how they will go about it after the assets have been transferred. Otherwise they can calculate a percentage wise calculation of the assets, how they will go about it. That is consensual. But if there is one person who has approached the court for a succession certificate or a letter of administration, then there should be no objection certificate from the other legal heirs, which is a must for the certificate. Now, there may be few people whom these people are not aware about their whereabouts. Then we just need to give the address of the legal heirs whose whereabouts are not known. So the court will send a notice to their address, and if they accept it, if they have any objection, then they come back to the court. If they don't have any objection, then the court will proceed with the issuance of the certificate. Sometimes the letters, the petition copy which has been sent by the court to the other legal heirs whose whereabouts are not known, if it comes back, then the court issues the paper notice, that is publication in the reputed newspapers. If there is an address of the legal heir outside Mumbai, that will come in a local newspaper. And if it is in Mumbai, then it will come in a English and a Marathi newspaper. That is all taken care by the court. But this is the procedure which I am telling. Once the paper notice is given, then we have got around 30 to 45 days of cooling period wherein nothing happens. We just need to wait if there are objections or if any other legal heir comes forth challenging this, or coming up with the caveat for the letter of administration telling that they have got objections. So this is all cooling period. So the time taken from the time of submission or filing of the petition in the High Court up till the issuance of the grant of the letter of administration or succession certificate is around 8 to 10 months time. It is not a 15 days procedure. It naturally takes time. So with that in mind, we need to, proceed. Then once that paper notice is given, if there is no one comes forth, then the procedure of issuance of the grant of succession certificate or the letter of administrations come forth, and the court starts the procedure of issuance of the grant. And then we get a grant, a proper certificate from the court telling that yes, this is the schedule of the property and this is the person who has come forth, and the succession certificate has been granted in this person's name, and he can go forth to the respective companies, submit the succession certificate and get the assets transferred in his ownership. Now, some people have got a query, once the succession certificate has been issued for some mostly in movable properties, for example, the share companies. Few people, they get a letter of request from the shares company telling that this is the total shares which you have got. But later on, maybe after the grant has been given by the court or the succession certificate has been issued by the court, few people come back telling that, I think so 2 or 3 shares were not included in that. We were not aware of that. Now, when we looked into our records, we found there are 3 more companies' shares which have not been included. Well, we can, after the issuance of the certificate also, we can apply for it, giving a reference of the earlier succession certificate or the grant which has been issued, and amending the petition wherein the court fees need not be paid. The court fees is taken of the earlier court fees which has already been paid by the person. So it will be a minimal amount which needs to be paid for the balance which has been found, balance shares of mutual funds which has been found later on. So this is one main query which people think, like, if there is anything left over or which has not been taken into account, what is the solution? Now, this is regarding the succession certificate. Now, letter of administration, which is for properties in and around Mumbai. In that case, then the letter of administration, which has been issued by the court, can be shown in the society, and then accordingly the ownership can be transferred to the person in whose name the letter of administration has been issued. So these are the two things in the succession certificate. One, what I have spoken is about succession certificate, and the second is letter of administration. Now, few people have got a query about succession certificate, letter of administration, and now what is this legal heirship certificate? Now, there is a lot of difference between legal heirship certificate and succession certificate. Now, in succession certificate, the court stands as an executor and nominates one person who can transfer the assets in his name. But in legal heirship certificate, the court only confirms the legal heirs. Who are the legal heirs for the person? The deceased person's legal heirs are these men. But it doesn't say whose name the property needs to be transferred. And in legal heirship certificate, there are two types. One issued by the court and one issued by the district collector. If a person who is employed in a government service, he can go through the registrar or the taluka office, wherein they issue the legal heirship certificate, and it doesn't take time. Maybe in 30 to 45 days, a legal heirship certificate has been issued. This is all about legal succession certificate, letter of administration, and legal heirship certificate. This is in brief what I've told you all about succession certificate and letter of administration. And now there are many societies who are asking for letter of administration for the flat and land wherein the person has died interstate, because the rules and regulations under Mumbai High Court are becoming a little stricter, because there are many frauds which are happening for the ownership. So this may become a compulsory thing in the near future.
Can we carry on with the inheritance procedure without obtaining a succession certificate?
People are little reluctant कि अरे भाई इतना पैसा कहाँ से भरेंगे हम लोग. 75,000 is not a very small amount. It is a big amount. That's why I told you all, please have the nomination filled when you all are there. Please fill in the nomination form for the movable properties. For the immovable properties, now sometimes what happens when there is nomination, there are cooperative housing society bylaws by the Maharashtra Cooperative Housing Society. In that, there are, if you go through bylaw 34 and bylaw 35, somewhere there are it clearly says where there is nomination and where there is no nomination. Where there is nomination, then we can, indemnity bond, affidavit from the legal heirs, we can fill it up and as well give it to the society. The society accepts it. And to make ourselves clear, some people even go and do a release deed at the registrar's office so that others release their rights, and this procedure is completed. If there is a nomination, then as per another bylaw, we can submit. That all depends on the legal panel which is in that cooperative housing society. But for the movable properties, that is the banks and the share companies, if there is no nomination, they specifically ask for a succession certificate, even if the amount is very, very low, as much as 25,000. Also, they ask for a succession certificate if there is no nomination.
Ma'am, can you shed some light on revocation of a succession certificate?
The succession certificate which has been issued by the court, then you need to file a petition against that in the High Court itself. Revocation, matlab you mean cancellation or cancelling of that succession certificate, right? Which has been issued. That is what you said, revocation.
Yes, ma'am.
Then that petition needs to be filed in the High Court. Sometimes what happens is, when the succession certificate petition is filed, the court sends some notices to the other legal heirs. And if the legal heirs have got some problem, they can file a caveat against it. Those people are called the caveators, wherein they have got a problem. They don't want this particular person to be the legal heir. They want all of these people, they want to come forward telling that, no, he is not only the legal heir, even we are there. Sometimes what happens, people go ahead to the High Court and they submit the petition for the succession certificate or letter of administration without informing the other legal heirs. Then when the court sends the notices to the particular people, the other legal heirs, then they can come forward as a caveators, giving objections against that petition which has been filed. This is during the time of the procedure.
And ma'am, what is a legal heirship certificate?
It is dependent. In succession certificate, what happens? The court stands as an executor and it allocates, telling that, okay, this flat need to go to this legal heir. But in this, it is very specific. This flat is there or this shares are there which needs to be transferred into this person's name. But in legal heirship certificate, what happens is court only clarifies the deceased person's legal heirs are these people. The court doesn't say this property goes to this person. It only tells Advocate Akshatha Prabhu has got one son who's only the legal heir to her. He is the legal heir to Akshatha Prabhu. It doesn't define ki Akshatha Prabhu's flat needs to go to that person. Legal heirship certificate, when it is issued, in case there is, for pension or, the person when he dies during his employment in when he is in the government service and his son wants to take his place during his service, then the son goes and asks for a legal heirship certificate telling that I'm a legal heir, so the job needs to be given to me.
Ma'am, any tips on how to distribute gold jewelry and silver placed at home among the...
This you're talking with regard to succession certificate or a will?
Ma'am, if there's a will, then will define it. Ma'am, there's just a question that how can one distribute the gold jewelry?
See,
we might not need a succession certificate for that, right? If all the...
Yeah, see, now when I make the will, I have told you earlier that also even I make will for senior people. Now the senior citizens, they have got very emotional value for the gold or jewelry which they have made. They don't want it, once it comes into the hands of the legal heir, they just tolmol karte hain. Acha theek hai, there are 10 grams, 5 aap rakho, 5 main rakhta hu. That means they go and sell it out. So I usually tell these people ki, these jewelry is there. When you're making the will, make it into 3 boxes or 2 boxes. If there are 2 legal heirs, make into 2 boxes and keep it in that box with the name written in that. And that name needs to be given in the will, telling that the orange box needs to go to this person and the green box goes to this person. Because senior citizens feel that, sometimes when making the will, taking the jewelry for certifying or weighing, it is a lot risk to take it to the jeweler's shop, bring it back home. So I usually tell them make 2 or 3 boxes for the legal heirs, having a different colored boxes and writing a name on that for whom it is given. This is a very easy and not very legal way. But, to safeguard their interest, I tell that. And in succession certificate, you can name them whatever they have.
So I have a case in which a share certificate of flat is in the name of mother and second name is mine. Now mother expired 2 years before.
Okay.
Without will. And the society is asking for the succession certificate. But I don't have brother, sister. I am the only son of mother. Father is also not there. So I argued with them that my name is already there in the certificate. Mother is already expired. The second name is mine. This should be transferred to my name automatically.
Yeah.
And I can enter my wife's name along with that.
That will be later on. That will be later on.
Yeah, but before that also, do I need to go for the succession certificate? My name is already there in the certificate.
Sir, first of all, this is for in the cooperative housing society.
Cooperative housing society flat is there. Yeah.
First of all, it is not succession certificate. It is letter of administration. What they might be asking for. So
It
वो
is
wrong है.
specifically told succession certificate.
No, that is not succession certificate. That is letter of administration.
Okay.
Sir, आपका कहाँ पर है ये society in suburban or rural?
नहीं, Mumbai 2.
Mumbai 2. अच्छा
हाँ.
सर, you just speak to the society committee members.
हाँ.
मतलब aggressively मत बात करो, प्यार से
हाँ.
बात करो.
हाँ.
क्यों अपने को अपना काम से मतलब है?
Yes.
You know, so you can just tell them कि I have checked with my lawyer. Who does succession certificate and letter of administration. First of all, for flat, it is not the succession certificate, it is letter of administration. ऐसे बोलते हैं वो लोग थोड़ा ठंडा हो जाएंगे. And then what you can tell is as per the bylaws of the Cooperative Housing Society, Maharashtra Cooperative Housing Society,
Yes.
The second holder becomes the owner of the flat, provided he confirms to them there are no legal heirs, first of all. And second, you need to fill up the indemnity bond. Various forms are there, जैसे for Appendix 7, Appendix 4, and maybe giving in the notice in the newspapers for legal heirs. मतलब society, what they want is, you know, telling that, you know, there might be a legal heir who can crop up.
Yes,
मतलब
yes.
they also,
That's what they say.
Yeah. So you can tell them, sir, we can give a paper notice if you all have got so many problems. अब दो पेपर में अपना one is in English newspaper and one in Marathi newspaper. In two newspapers, you can issue a public notice telling that you have come forth for the ownership of that. And you know, if there is anybody, either the society can give and you can pay for that, or you can take the services of the lawyer. The lawyer will do the entire bylaws के हिसाब से stamp paper के ऊपर appendix का typing, notary, registration of the notary, various appendixes are there. Plus give a notice in the Marathi and English newspaper, and then the lawyer needs to give a no claim certificate telling that there have no been claimants who have come to me claiming the ownership of the society. So we request you to transfer it in there. And last एक line भी लिख सकते हैं telling that if there are any issues in future, the entire legal procedure will be handled by us, and there will no issues will be given to the society. ये ऐसे कुछ लिख के and then a transfer form भी करना पड़ता है, वो पूरा set रहता है sir. There is a proper set, and then once it comes into your name, then you can fill up a form 14 for the nomination of your wife or a joint holder or an associate member. वो सब बाद में. First ensure that it is transferred into your
First
name.
is this,
Following the Maharashtra, और प्यार से बोलो sir, society वालों को, they also understand.
So only by giving affidavit, this will not be sufficient.
नहीं, that's what you need to follow the procedure of the Maharashtra Cooperative Housing Society bylaws. तो वो bylaw 34-35 दो है, आपको उसको refer करना पड़ेगा. Wherein there is with the nomination and without nomination. And sometimes people even do releasing the other legal heirs' rights. But in your case, I don't think so. There is a necessity of release it because there are no legal heirs. ये bylaws में आप follow करोगे, so everything will be set right, sir. And talk to them nicely. They are also honorary members doing some work out of their busy schedule.
Yes.
So yeah, talk nicely. They'll do it, sir. Don't worry.
Ma'am, even if son is alive, can the daughter-in-law apply for the succession certificate or letter of administration for father-in-law?
Father-in-law is deceased.
Yes.
Mother-in-law?
Both are deceased.
पहले तो the son has to apply, na, ma'am?
Okay.
Yeah, the son is the direct legal heir to the father's property.
Only if son is not alive, then daughter-in-law can apply.
Yes, daughter-in-law. In that also, the first right goes to the children, grandchildren.
And secondly, ma'am, this certificate is a like personalized kind of a thing, like or suppose one heir applies for that, even the other brothers sisters can use it for.
No, I mean succession certificate is issued in the name of the people who are the legal heirs. Plus, who will take the responsibility of the जिसके नाम पे ownership जाना है.
हाँ, लेकिन जैसे मैं हूँ, मैंने अप्लाई किया, मुझे मिला, अभी मेरी सोसाइटी में मैं वो सबमिट करूंगी, लेकिन मेरे भाई भी हकदार है, तो मेरा भाई को भी वही सर्टिफिकेट चलेगा या उसको फिर से अलग अप्लाई करना पड़ेगा?
One succession certificate for 3 members can be issued फिर उसमें परसेंटेज वाइज देना पड़ेगा मैम।
अगर हिंदू सक्सेशन एक्ट के हिसाब से एक विल नहीं बनाया है तो 3 हेयर्स है तो तीनों को इक्वल जाएगा ना?
Yeah, that you need to count, do it a percentage wise and give it to the court कि इसको इतना percentage, इसको इतना percentage, इसको इतना percentage. Then the court will decide how it will do it. तो तीनों का नाम आएगा मैम इसमें।
तीनों का तो फिर वो कॉमन सर्टिफिकेट आ जाएगा जो तीनों
Yeah.
अपने अपने हिस्से के लिए यूज कर सकेंगे।
या अब इसमें सर्टिफिकेट मतलब क्या आता है? इट इज जस्ट द कॉपी ऑफ द पिटिशन। जो हम लोग पिटिशन देते हैं ना कि इतने लीगल हेयर्स है, उसमें ही कोर्ट एक स्टैम्प मार के देता है टेलिंग दैट दिस इज द ग्रांट। मतलब इट इज जस्ट लाइक अ पिटिशन, वॉट एवर वी हैव आस्क्ड फॉर, वो उसमें स्टैम्प वगैरह मार के ये दिन में इतने सक्सेशन सर्टिफिकेट इनके नाम पे दिया है करके।
जो लीगल हेयरशिप सर्टिफिकेट है उसके लिए भी कोई कोर्ट फी प्रिस्क्राइब है? और सेकंड क्वेश्चन है, बेटर टू अप्लाई टू कोर्ट और टू कलेक्टर?
अच्छा मैम, कलेक्टर का यहाँ पर होता है ओनली इफ इट इज अ गवर्नमेंट एम्प्लॉय।
Oh, okay. So we have to apply, but there is any court fee 75,000?
Yeah, it is same as
For legal heirship also 75,000 is the maximum.
Yes. And
Okay,
one more thing, in legal heirship certificate, आप जब भी कोर्ट में अप्लाई करोगे and when it goes to the in front of the judge will ask you only one question कि why have you applied for legal heirship certificate and not for succession certificate? Because हम लोग जब भी when we apply for succession certificate petition, when we submit the petition, the court accepts and does the procedure. But in legal heirship certificate, we need to give the requirement जहाँ से from where the requirement has come. In case the society is asking for the legal heirship certificate, society has to issue a letter telling that we require the legal heirship certificate for such and such purpose, which becomes a part of the petition, ma'am.
So it's better to apply for rather succession certificate or letter of administration instead of legal heirship certificate? Because cost is same, but the coverage is much better than
better and clearances. You get a clear picture, and secondly, jurisdiction भी same है, and then time limit also is the same. कहीं पर भी कुछ ये नहीं है. It is only as per the requirement. So
better to apply for succession certificate of letter of administration rather than applying for legal heirship.
Yes, ma'am.
And if any single heirs of the deceased person, then also need a succession certificate.
Yes, if there is no nomination, sir.
If a will is made of a self-acquired property, then and the property, let's say the land is in the Gram Panchayat area, then the succession laws will not come into picture, na? Because the why the query is that the Talathi of that particular Gram Panchayat is asking to register all the legal heirs, even though affidavit is given that this is the will, and in the will the particular on whose name this property has to be transferred is clearly mentioned, and still the Talathi is asking that we'll have to register all the names, then we will have to remove them.
I think so. There that Satbara comes into picture, right?
Satbara, in the Satbara name.
So वो तलाटी बराबर है. He will tell that because Satbara is one wherein all the legal heirs names has to be mentioned in that.
Okay, no, but other legal heirs all have already given the release deed that they don't want any share in that, even after the demise of the owner. And they have given all the share to a name whose name is already mentioned in the will. Okay. Still they are asking, is there any law where we can tell them that you need not register, directly implement the will?
No, matlab, these release deeds you have got, right? Registered, na?
Registered, yeah.
Registered.
And it is also mentioned that even after the demise of the owner, they don't want the share has to be, they are releasing the share in the name of the person already mentioned in the will.
अच्छा, तो ये कहाँ का प्रॉपर्टी है?
It's in Alibag, ma'am.
So it's better अलीबाग में जो है ना कोई भी lawyer, you better get in touch with them who knows the proper procedure there.
In the will, let's say there are 5 or 6 properties mentioned, and one property the owner does the gift deed
Gift deed, yeah.
in the favor of a person already mentioned in the will. So
Huh.
that will be still valid only, no? For the rest of the
So,
property.
see, now the gift deed was made after the will was made or what?
After the will was made, yeah.
हाँ, तो will, when we make a will, you know, the gift deed क्या होता है? Once you make the gift deed, so gift deed is a document which immediately transfers the rights to the person whose name the gift has been done.
Yeah,
It does not wait till the person dies.
yeah. But for the remaining property, it's the will is still valid only, no?
Yes, yes, yes. That's why when I make a will, I write
Right.
below as a last paragraph telling that any property
Okay.
which has been gifted or which has been acquired after the registration of this will be
Okay.
as per the nomination or the gift deed present. This is the last paragraph which I write, so that we cannot make a will every now and then, and registration of the will is also a pain. So in that last paragraph I write telling that any property which has been gifted among the properties which I have listed, or any property which has been acquired after the registration of this will mainly be on the basis of the nomination there. तो ये gift deed का जो है ना, you can immediately transfer into the person's name, and the rest can be done after the death of the person.
Ma'am, me and my father have purchased one property in Titwala. Yes,
In
my
Titwala.
father is in Titwala, and my father died in 2018. My sisters are not giving release date. So what to do?
It's a joint name property, right?
Yes, sir. Yes,
So
ma'am.
the 50% in that is yours. The other 50% in that also there are 3 shares, one yours and other 2 your sisters.
Yeah,
The money which went for this was from whom?
from me and my father.
Exactly. So the fathers on the property, the daughters have got equal right.
I am giving ma'am them, but they are not allowing to do the release deed. So what to do for this? Is there any option for that?
Then you need to go in through for a civil matter.
It will take too much time for that.
I know. There is no other. Otherwise, what you need to do is, जो आपका है, आप रखो अपने पास, and what they exactly want, what the sisters want. They don't want to sell the property. What they want.
They are not saying anything, ma'am. They are just saying that I am not going to give a release date. That's all.
But what you want to do with the property? That is another question.
I have to take my loan. I have to take a loan on this property to buy a new home for me, new for me. So that's why I'm asking them to give a release date. So whatever the payment is there, whatever the monies you want, I am ready to give. But they are not allowing.
Maybe they have got a emotional side for that ki dad ka property hai, kaise bheje, that is one. What you can do is if you have got a proper mediator, a common relative who can sit with all of y'all, 3 of y'all, make them understand what is your point in selling the property. Ye matlab I'm not telling legally, this is I'm telling a shortcut way. Have a mediator sit in between, maybe an uncle who is known to all the 3, and all the 3 of y'all respect that uncle, your dad's brother or your dad's sister. Tell your dad's sister or your dad's brother, telling that why you want to sell the property and what is behind it, and have a mediation meeting happen. Because if you go for a court procedure, it will take time. Succession certificate ka rehta nahi isme kuch problem. So so it's better have a mediator and make a proper understanding between 3 of y'all, and then have the property dispersed. If not, then send a notice through a lawyer telling that this is why I need to sell. Let them revert with that their reply in written. Then you can understand what they have in their mind. No? The mediation is better. That keeps your relation also properly. In your long run, in future, brother, and at the end, you're like brother and sisters, yaar, ek property ke liye kyun jhagadne ka?
Yes.
Like suppose, there are about 3 properties, and the successors are also the same. So, do we need to pay the 75,000 for three different properties separately, or
No,
can
no,
have a
no.
joint thing? can
No,
be
no,
done?
joint. You only thing what you need to do is when you put the schedule of the property, you need to mention all the three properties in one succession certificate petition.
Okay, so it is not asset wise.
Not asset wise, total asset about 10 lakhs, 75,000 asset.
Okay, but so for example, like suppose there's one property in which we have three successors, in another we have two successors, so that entire thing can come in one petition.
Yeah. Only thing is when you make the petition, write all the successors, all the legal heads,
Okay.
or make it in one person's name with other NOCs, with the mutual understanding between you all, ki how the property will be divided. Or in case if the other legal heads are not ready for it, then you'll make the succession certificate or the letterhead of administration in all the legal heads' name or the successor's name.
Okay, fine. Thank
And
you.
the schedule of the property, all the three need to be written there.
NOC should be on the stamp paper or on the plain paper or lettered.
No, sir. That's the plain paper NOC.
NOC. Acha, one more
Yeah.
thing. If the NOC is given by brothers and sisters, they are no more. I'm the only heir left. Then whether it is for succession certificate.
No. Then if
In that NOC, they have mentioned that we or our heirs have not have no any right on that kind of thing.
no, when during the lifetime they had given you the NOC.
During the lifetime they had given, but
Okay.
they are
Now they are no more.
yeah.
And when are you applying for the succession certificate now?
So I'm thinking whether I should apply or not because of some shares and things like that. So I'm not sure.
In this, what happens if you're applying for a succession certificate or a LOA, that's letter of
Yeah.
administration,
Yeah.
then what happens is their legal heirs come into picture.
Okay.
And what NOC they had given during their lifetime, it is not valid now for succession certificate.
Okay.
You need
Fine.
to take a fresh NOC from their legal heirs. You can just show these earlier NOCs to their legal heirs, telling that your father and mother had told your legal heirship, your rights are also released. So,
Yeah.
but the court is asking for a fresh, since they are no more, you need to give a NOC now.
From their heirs.
Yeah, from their heirs.
Okay, fine. Because they are abroad, that means we are in touch, no issue. But generally, I ask if required.
No, if they are abroad and if they are ready to give a NOC,
Huh.
then the consulate can do what we do notary here. The
Yeah.
consulate there can give a stamp and verification.
Yeah. Acha, if the person, my mother has left a will behind, whether that probate is mandatory to issue the store the succession kind of thing.
No, see, if there is a will, you can do a probate of the will.
Yeah, whether it is mandatory to transfer the flat in the society.
नहीं, it depends. मतलब society के पास ही बात करना अच्छा है. What they require.
Okay, because
If the society tells we are okay with the bylaws of 34 and 35,
yeah,
तो आप succession certificate क्यों जाओगे?
means if I give the probate and all, it depends upon society people approach, and if I show the will,
Yeah.
they may not insist kind of thing. Huh?
Yeah, they may not insist, and still if you want to be very clear, then you can do a probate of will. Because in future also there will be nobody else who can approach you or take an objection on the transfer.
There's this property of my father. He is deceased. He died in 2021. Then my mother also passed away in 22. So we are three sisters. And as of now, we don't want to do anything with the property. We are keeping it. But in future, if there is a requirement, we would like to sell or rent it. So I wanted to know if this is a requirement in the future, is it wise enough to proceed for succession certificate in this case at this point now, because it takes time, and should we, start the process? Or
no, but ma'am, having a succession certificate will not harm anything. But as per requirement, karo na sir, ma'am. As and then you just check na.
Okay, so it's not required at this point, right?
No, you need not. In case will bhi nahi hai kya? There is no will.
No, interstate hai, ma'am.
Interstate hai. So movable, immovable, both the properties are there.
Only immovable, like flat hi hai, ma'am.
Acha, flat hi hai na. So what you can do is check with the society, give the submit the death certificate of both your father and the mother, and
All
tell
right.
them we 3 legal heads are there. You suggest, before that you all decide between yourselves what you all need to do about it, because you can't
Yeah.
keep a flat in the deceased's name. It needs to be transferred in somebody's name, na?
Okay.
So you need to submit the death certificate to the society telling this both people are not there.
Okay.
So you check with the society. Before that, your sisters sit and decide what needs to be done, and
Correct.
then approach the society giving the death certificate, and check with the society how to go about it, the procedure.
So the other question, ma'am. So succession certificate is necessarily in the name of one heir, or it can be in the name of all the 3 heirs?
All the 3 heads, ma'am.
After we receiving the succession certificate, can
Yeah.
I apply for amendment? Because I forget to add some debentures and shares.
This happens with everyone. It is not only you or me. It happens with everyone, because the share company comes with another telling that unke naam pe aur ek hai shares. So, in this what happens is we have already paid the fees in the original succession certificate. We have already established the ownership. So only thing is amendment petition submit करना रहता है without any court fees and all. Only minimal जो भी है खर्चा वो करना पड़ेगा sir.
Okay, fine.
Amendment हो सकता है, but you need to give the reference of your original petition number or the grant, copy of the grant which has been issued to you by the High Court.